Rule 5.110. Address designation for personal representatives or guardian designation of resident agent and acceptance. Address designation of personal representative or guardian. Before letters are issued, the personal representative or guardian must file a designation of street address and mailing address. If the personal representative or guardian is an individual, the designation must also include the individual's residence address. The personal representative or guardian must notify the court of any changes in its residence address, street address, or mailing address within 20 days of the change. Designation of resident agent. Before letters are issued, a personal representative or guardian must file a designation of resident agent for service of process or notice, and the acceptance by the resident agent. A designation of resident agent is not required if a personal representative or guardian is 1. A corporate fiduciary having office in Florida, or 2. A Florida bar member who is a resident of and has an office in Florida. The designation must contain the name, street address, and mailing address of the resident agent. If the resident agent is an individual who is not an attorney, the designation must also include the individual's resident address. Residency requirement. A resident agent other than a member of the Florida Bar who is a resident of Florida must be a resident of the county where the proceedings are pending. Acceptance by resident agent. The resident agent must sign a written acceptance of designation. Incorporation and other pleadings. The designation of the address of the personal representative or guardian, the designation of the resident agent, or acceptance may be incorporated in the petition for administration, the petition for appointment of the guardian, or the personal representative's or guardian's oath. Effect of designation and acceptance. The designation of and the acceptance by the resident agent shall constitute consent to the service of process or notice on the agent and shall be sufficient to bind the personal representative or guardian in its representative capacity in any action, and in its personal capacity only in those actions in which the personal representative or the guardian is sued personally for claims arising from the administration of the estate or guardianship. Successor agent. If the resident agent dies, resigns, or is unable to act for any reason, the personal representative or guardian must appoint a successor agent within 10 days after receiving notice that such event has occurred.
If you're interested in any of our services, please call 321-206-3603 or visit easlerlaw.com to book a consultation.